Hi everyone, I am Akash Srivastav and I am here with Law Wednesday session. In this session, we are going to discuss about a very important and sensitive topic, that is marital rape an exception to section 375 of IPC? So you must have heard about this particular term marital rape a lot of times. You must have heard and read about this on Instagram, on Facebook, tweets on Twitter. So again, when we talk about this particular term, it is very important from point of view of law, you should be aware what exactly it is. So when we talk about the term rape, everyone, every layman also, whether he have any background related to law or not, he is aware ki what exactly rape is. But when we talk about marital rape, it becomes very important that you should understand the ambit of it, what exactly it is and how is it different from rape. So in today's session, we are going to discuss in very brief what exactly rape is and how marital rape is different from rape, and whether marital rape is an exception to rape that have been defined under section 375 of IPC or not. So let's start the session, guys. So the first thing is that rape law in India. So according to section 375 of IPC, rape law is defined under it. So when we talk about IPC, it basically means Indian Penal Code 1860. So all the crimes that are in India that you can be criminalized for, that is everything is mentioned over here only in IPC, and IPC section 375 specifically talks about rape. It's a very technical definition that have been given over here. So all the details are provided over here. But when we talk about the gist of it, the summary of it, you can say that sexual intercourse with a woman against her will is known as rape. So there are few technicalities involved, but again the gist of it is that if you are having a sexual intercourse with any woman without her consent, then that would amount to rape. So moving ahead, guys, the second point of discussion in today's session is that what exactly is marital rape. So as you can just understand by the term that have been mentioned over here, is that rape committed by a person to whom the victim is married. That means his or her husband. So when we talk about if there is any particular spouse and if there is any particular married couple and husband is raping wife, so crime is committed against women. So this particular act will be known as marital rape. So it is very important to understand whether this particular term have been defined under law or not. So before we discuss what exactly law states, it is very important to know the ratio that have been given over here, the stats that is given over here. So you can see on the screen that out of 100% rape, so 82% rape are committed by the husband itself, and very few amount of rape, very few percentage of rape is committed by outsiders. As you can see, only 0.2% rape of a married woman is committed by outsider, and other, so 99.8% are rape committed by either husband or former husband or immediate family member. So when we talk about when we talk about marital rape, the ambit is too vast. But in today's session, we are only discussing whether marital rape is an exception to section 375, that is rape or not. Whether marital rape is an exception to rape or not is today's point of discussion. So according to section 375, there are two exceptions that have been provided, that if this particular act is committed, then that would not be termed as rape. The first one is the medical procedure that we are not going to discuss, obviously. The second exception is that if sexual intercourse is done by a man, by a husband on his wife, and wife is above 15 years of age. So if she's not below 15 and if she's above 15, wife is above 15 years of age, then it will not be termed as rape. So if a husband commits rape with his wife of say age 16, 17, 18, then that particular act will not be termed as rape and he will not be liable for rape under section 375 of IPC. So when we talk about IPC, the year of enactment was 1860, but a lot of changes have been done to it. So there is one particular act that is known as POCSO Act. So when we talk about the full form of POCSO, it is Protection of Children from Sexual Offences Act, and the year of enactment was 2012. In this particular year, this act came into picture, and according to section 2 clause 1 subclause D, it states that the definition of child, and according to the definition of child that have been defined under POCSO Act, it states that any person who is below 18 years of age will be termed as child. So now the conflict arises between IPC 1860 and POCSO Act 2012. So according to IPC, it's saying that if there is a child, it's a girl of 16 years, 17 years, 18 years, anyone above 15 years of age, and a rape is committed by her husband on her, then that would not be termed as rape. But according to POCSO Act, it is stating that any sexual abuse that have been done on a woman below 18 years of age, then that would be termed as, that would be criminalized. So now the conflict between the two acts is that the first act is saying that above 15, no rape. And the second act is saying that if the girl is below 18, then that particular person who have committed sexual abuse against her will be criminal in nature. So this is the conflict between these two acts, and the resolution or the solution of it was given by a judgment of Supreme Court that is known as Independent Thought versus Union of India. In this particular judgment, Supreme Court basically made both these acts in aligned. So they said that it is very important for us to make it very clear that of which age. So what exactly should be the age? Because there is a conflict between these two acts, IPC and POCSO Act. So in this judgment, what exactly they did? They amended IPC, exception 2 of section 375 of IPC. And what they did, they said that instead of 15 years, we will keep it as 18 years. Now, POCSO also and IPC also, both these acts are talking about the same age. But again, the solution is whatever is provided by the Supreme Court is not complete. So if we are saying that if a husband is raping his wife who is 16, 17 or 18 years old, then he will be criminalized for that. He will be punished for that under section 375. But again, what about a wife of 19 years old, 21 years old, 25 years old? There is no solution provided for that. So when we talk about the main content or the main point of discussion of today's Law Wednesday session was whether marital rape will be covered under exception or not under section 375. So it will be covered under exception, but only for underage wife, that is minor wife. So if there is any particular person below 18 years of age, then that will be covered under the exception. But again, beyond that, husband will not be liable for rape. As for example, if he has committed the same act with anyone else apart from his wife, then he would have been liable for rape. But when we talk about if he is married to someone and is committing the same act, whatever is mentioned under section 375, then he will not be liable for that. So analysis of the whole law is that there are two drawbacks. When we talk about the important judgment that has been passed in 2017, that is Independent Thought judgment, in that judgment, it has been specifically stated that whatever crime we are talking about, whatever victim we are discussing, the whole judgment is prospective in nature. That means that post the judgment is given, after that if any victim comes to us, then this particular 18 years wala clause will be applicable. Before that, it will not be applicable. So just understand the chronology that from 1860 to 2012, if a husband is committing rape against his wife who is minor, then in that case, he is not liable. From 2012 to 2017, it's a bit dicey because the act or the judgment that Supreme Court has passed is specifically stating that this will be prospective in nature. Once the judgment is passed, we are not talking about the retrospective nature of this particular judgment. We are talking about the prospective nature. So what happens to all the victims from 2012 to 2017, it's not clear. And the second point of lacuna or second point of solution that we still need is that what happens to all those wives who are above 18 years of age. So the way forward basically is that when we talk about marital rape, so rape is one particular crime that everyone is aware of, even if when we talk about whether it is a jurisdictional law only applicable to India or throughout world, it is applicable throughout the world. When we talk about number of countries, out of 185 countries, more than 77 countries have passed law criminalizing rape, marital rape. When we talk about the countries have not passed any particular law or who decriminalizes rape, then that is more than 30. And India is among one out of 34 countries who have said that we should not be treating marital rape as equivalent to rape. So the main agenda in today's session is that you must have heard that there are a lot of protests going on regarding this particular amendment, that there should be amendment in section 375 and exception 2 should be amended or removed, and marital rape should be treated at par with rape. So the way forward is that first of all, there are few lacunas, there are few problems with making this marital rape as rape or equivalent to rape. The first point is that when we talk about the definition of sexual intercourse or sexual intercourse between spouses, it's very private in nature. No one should be aware and should interfere in the sexual activity that they're having within the four walls. So it becomes very problematic for wife to raise voice against husband and also to prove it. So the first point that is with the legislature is to make some law in procedure law that defines how a wife can file or how an advocate can prove this particular crime in court of law. And once that is done, once procedure is established by law, then a substantive law can be made, or exception 2 from section 375 can be removed. So this is the only solution that is available with us, that first of all we should focus on procedural aspect of it, that how an advocate can prove it, how a woman can prove that she has been raised by her husband before the court of law. And the second point is that once we are done with that, once we have established the procedure, the second point would be to make a substantive law, or to make changes in IPC. So this is all with respect to today's session, guys. In today's session, we discuss about marital rape, whether an exception to section 375 that defines rape under IPC or not. So overall, we got to know that when we talk about the judgment of independent thought, it aligned both the POCSO Act and IPC, but again, all the wives who are major in nature, who are above 18, no solution is provided for that. So I hope this session was informative enough. We will definitely meet in future and discuss many more important law topics. Thank you guys. Have a nice day.